Morning friends, this so that you're thorough with MCQ, and once we are thorough with MCQ we will move on to the mains writing followed by the interview viva voce. So without wasting time, let's move on with the questions. Our first question is whether an issue heard and finally decided by a competent court of limited jurisdiction shall operate as res judicata in a subsequent suit that the aforesaid court was not competent to try. We have got four options here. Option A says no, option B yes, option C answer will depend upon the nature of the issue, and option D none of the above. So the correct answer is yes. Please read section 11 explanation 8 of CPC. Let's move on to second question. An immovable property held by Y is situated at Bhopal and the wrongdoer personally works for gain at Indore is sued to obtain compensation for wrong to the property may be instituted. We have got four options here. Option A says at Bhopal, option B at Indore, option C either at Bhopal or at Indore, option D none of the above. So the correct option is option C, that is either at Bhopal or at Indore. Please read section 16 proviso clause. Okay, so let's move on to third question. Where the liability in relation to a sum adjudged has not arisen, this is very important, not arisen out of a commercial transaction, the maximum yearly rate of interest awardable under section 34(1) of CPC from the date of decree for the payment of money to date of payment is, we have got for option here. Option A says 12% and option B says 18%, option C 10% and option D 6%. So the correct option is option D, that is 6%. Let's move on to fourth question. If in any case in which the defendant sets up a counterclaim, the suit of the plaintiff is stayed, discontinued or dismissed, the counterclaim shall be, we have got for option here. Option A says be stayed, option B says nevertheless be proceeded with, option C says may be continued with the leave of the court, and option D no specific provision is made. So the correct option is option B, that is even though the counterclaim the plaintiff's claim is stayed, discontinued or dismissed, the counterclaim shall nevertheless be proceeded with. Please read order 8 rule 60 of CPC. Let's move on to fifth question. Whether decree is for the payment of sum of money exceeding 5,000 rupees. This is very important, exceeding 5,000 rupees. The period of civil imprisonment shall be, we have got for option here, shall not exceed 3 months, option B shall not exceed 6 months, option C shall not exceed 9 months, and option D shall not exceed 1 year. So the correct option is option A, that is shall not exceed 3 months. Let's move on to sixth question. Who among the following is not entitled to exemption from personal appearance in court? So we have got for option here. Option A, formal Indian ruler, option B, chairman of a state legislative council, option C, minister of states, and option D, collector. So the correct option is option D, that is collector. Please read section 33 of CPC. Let's look into seventh question. Caveat shall not remain in force after expiry of how many days? We have got for option here. Option A says 90 days, option B says 60 days, and option C says 30 days, and option D says 15 days. So the correct option would be option A, that is 90 days. Please read section 148A of CPC. Let's move on to eighth question. Eighth question is, if a party who has obtained an order for leave to amend pleading does not amend the same within how many days, he shall not be permitted to do without leave of the court. So we have got four options here. Option A says 15 days, option B says 14 days, and option C says 20 days, and option D says 30 days. So the correct option is option B, that is 14 days. Please read order 6 rule 17 and 18 together. Okay, rule 17 and 18. Let's move on to ninth question. Where the plaint has been rejected, the plaintiff on the same cause of action, what will be the effect of rejection of the plaintiff's claim? So the rejection is provided under order 7 rule 11. You remember this is the rule. Order 7 rule 11 is about the rejection of the plaint, and its effect is here order 7 rule 13. So if you have read these two order and rules, you can give the answer very easily. But if you haven't read the order 7, then please go and read the order 7 rule 11 and rule 13. So we have got four options here. Option A says may present a fresh suit. Option B says cannot present a fresh suit, and option C says may present a fresh suit with the leave of the court, and D says none of the above. So correct option would be option A, that is may present a fresh suit. May present a fresh suit. So this is provided under order 7 rule 13 of CPC. Let's move on to 10th question. Is whether suit is dismissed under rule 2 or 3 of order 9 CPC, the plaintiff would do what? So we have got four option here. May bring a fresh suit subject to law of limitations. Option B says cannot bring a fresh suit. Option C says may bring a fresh suit with the leave of the court, and option D says may bring a fresh suit with the leave of the district court. So the correct option would be option A, that is may bring a fresh suit subject to the law of limitation. Now you remember this, if the suit is dismissed under rule 2 or rule 3, then the plaintiff may bring a fresh suit subject to the law of limitations. But if it is asking if the suit is dismissed under rule 9, then he cannot bring the fresh suit. This will operate as res judicata. Alright, so please read order 9 in all the rules of order 9. This will boost of your knowledge of CPC. So let's move on to 11th question. In which condition the officer in charge of prison may refuse to produce the prisoner for evidence despite court's order? The question is asking if the court has given an order to the jailer to produce the prisoner in the court, what are the situations or the circumstances in which the jailer can refuse to produce the prisoner before the court? So we have got four options here. Option A says where the prisoner is related to ruling party. Option B, where the prisoner is ex-minister. Option C, where the prisoner is government servant. And option D, where the medical officer has certified that the prisoner is unfit to be removed the reason due to the reason of sickness. So the correct option is option D, where the prisoner is unfit due to the reason of sickness. So this is the ground under which the jailer can refuse to produce prisoner before the court. So these were the 11 questions for the day today, and we will keep discussing it on regular basis daily. And I request you to keep watching it on daily basis. You don't have to read books, the bulkiest book, you don't have to go through them. Before you enter the exam, any upcoming exam, I make sure that you're thorough with the MCQ of preliminary stage, and we will move on to mains followed by viva and voce. If you haven't subscribed to my channel, please do subscribe, like, hit the bell icon, and so that you can get the regular notifications the moment I upload the new videos. Till then, thank you so much for watching, and have a